Question 66. Cousin Jim and Cousin Vinny own title to a property as joint tenants. Jim gets married and deeds half his interest to his new spouse, Gloria. Consequently, Gloria now has title to the property as A. Servient tenant B, separate property holder C, tenant in common D, tenant in fee simple. Correct answer is C, tenant in common. When Jim, a joint tenant, conveyed half of his interest to Gloria, it severed the joint tenancy with respect to that portion. Joint tenancy requires the four unities: TTIP, time, title, interest, and possession. When Jim transferred his interest to Gloria, the unity of title and possibly time were broken. Gloria now owns that half interest as a tenant in common with Vinny. Vinny remains a joint tenant with respect to the other half of the property, his original share, but as between Vinny and Gloria, they are tenants in common. Joint tenancy features equal ownership shares and a right of survivorship, meaning a deceased owner's share goes to the surviving owners. Tenancy in common allows for unequal shares and no automatic right of survivorship. A deceased owner's share goes to their heirs. Joint tenancy requires four unities: possession, interest, title, and time, while tenancy in common only requires unity of possession. Question 67. Which of these principles is used as the basis for the market data method of appraisal? A. Value, B. Utility, C. Substitution, D. Conformity. Correct answer is C. Substitution. The principle of substitution states that a buyer will pay no more for a property than they would pay for an equivalent substitute. The market data approach, also known as the sales comparison approach, relies directly on this principle. Appraisers find recent sales of comparable properties and adjust them for differences to estimate the value of the subject property, essentially saying, a buyer would substitute this comparable property for the subject property if the price were right. Question 68. Sometimes included in a security instrument, the clause stating that the instrument will have secondary priority against another mortgage to be taken in the future is called A. Secondary clause, B. Subordination clause, C. Recording clause, D. Lien position clause. Correct answer is B. Subordination clause. Most subordination clauses are found in mortgage and trust deeds securing purchase loans for unimproved land when the borrower plans to later obtain a construction loan. Lien priority is normally established by the recording date, but when a subordination clause is included in the earlier land loan, it means the later construction loan can take the first lien position. Question 69. A prospective buyer is being shown a property where someone died 5 years prior. If that death is known to the broker showing the property, the broker, A. must disclose the death to the buyer. B. is not legally required to disclose the death to the buyer. C. if the cause of death was AIDS, it need not be disclosed. Any other cause of death, and it must be disclosed. D. The property cannot be sold until at least 7 years have elapsed since a death at the property. Correct answer is B. is not legally required to disclose the death to the buyer. If someone has died on a property more than 3 years previously, it need not be disclosed to the buyer, whatever the cause of death. However, if a prospective buyer has asked about the death and the seller, or his agent has intentionally lied about it, it will be considered a fraudulent misrepresentation. Question 70. Back-end debt describes the borrower's debt obligations for A. Mortgage payments only, B. All monthly debt payments combined, C. Escrow payments before the property sale closes, D. Agency fees. Correct answer is B. All monthly debt payments combined. Back-end debt, also called the debt-to-income ratio or DTI, refers to the total amount of a borrower's monthly debt payments, including housing costs, mortgage, property taxes, insurance, and other obligations, car loans, student loans, credit card minimums, divided by their gross monthly income. It's a key factor lenders consider when evaluating a borrower's creditworthiness. Question 71. A dual agency is permissible if A. the agent deals impartially with each party, B. the agent carries out his fiduciary duties to each party, C. each party provides written consent to the dual agency, D. all of the above. Correct answer is D. all of the above. Dual agency, where a real estate agent represents both the buyer and the seller in the same transaction, is permissible only if all of the following conditions are met. A. The agent deals impartially with each party. B. The agent carries out his fiduciary duties to each party. The agent owes fiduciary duties: loyalty, confidentiality, obedience, disclosure, reasonable care, and accountability to both the buyer and the seller. This can be challenging in a dual agency situation. C. Each party provides written consent to the dual agency. Both the buyer and the seller must be fully informed of the dual agency relationship and give their informed, written consent to it. This disclosure and consent are crucial for the dual agency to be legal and ethical. It is advisable that dual agents be experienced and sophisticated in their approach to the agency. Also, exclusive buyer's agents are never dual agents. Question 72. An escrow agent must be A. Chosen by the seller alone. B. Known and consented to by both parties. C. A dual agent. D. Both B and C. Correct answer is D. Both B and C. An escrow agent is a neutral third party who holds funds and documents related to a transaction until all the conditions of the agreement are met. While an escrow agent isn't a real estate agent acting in dual agency in the traditional sense, representing both buyer and seller in the sale itself, the escrow agent does owe fiduciary-like duties to both parties in the escrow transaction. They hold funds and documents in trust for both buyer and seller and must act impartially. So, while the term dual agent isn't typically applied to escrow agents, the principle of them acting for both parties with fiduciary responsibilities is correct. Both parties must consent, and the escrow agent acts in a quasi-fiduciary capacity for both. Because the escrow agent is handling funds and important paperwork for both the buyer and the seller, both parties must be aware of and consent to the choice of escrow agent. The seller cannot unilaterally choose the escrow agent without the buyer's agreement. Question 73. A negligently or wrongfully performed act which causes a breach of a lawfully imposed duty is called A crime. B. Writ. C. Tort. D. Malfeasance. Correct answer is C. Tort. A tort is a civil wrong that causes harm to another, leading to legal liability for the person committing the tort. Negligence is a common type of tort. It involves a failure to exercise reasonable care, resulting in damage or injury to another. A breach of a lawfully imposed duty, if it causes harm, can be the basis for a tort claim. Damage is the financial loss or injury to a person caused by misconduct, mistake, or accident, a tort. Question 74. Owner Owen signs a written contract with buyer Bob to sell a property. 6 months later, Owen tells Bob he has changed his mind and will not go through with the transaction. What is the deadline, if any, for Bob to file a lawsuit to compel Owen to complete the purchase deal? A. 1 year. B. 4 years. C. 7 years. D. There is no filing deadline in such cases. Correct answer is B. 4 years. In California, the statute of limitations for a breach of a written contract, including a real estate purchase agreement, is generally 4 years. This means Bob has 4 years from the date Owen breached the contract to file a lawsuit to compel Owen to sell the property. Specific performance. Question 75. For a broker with a non-exclusive listing to be legally entitled to a commission, she must be able to prove that A. She was a licensed broker at the time of the property transaction. B. She found a ready, willing, and able purchaser for the property on the agreed-upon terms. Correct answer is D. All of the above. To earn a commission on a non-exclusive listing, the broker must meet all of these criteria. A. She was a licensed broker at the time of the property transaction. This is a fundamental requirement for any legal commission. B. She found a ready, willing, and able purchaser for the property on the agreed-upon terms. The broker needs to produce a buyer who is financially qualified and prepared to purchase the property under the terms specified in the listing agreement. C. She was the procuring cause of the transaction being closed. With a non-exclusive listing, the broker must demonstrate that their efforts were the direct cause of the sale. This is the most crucial and often disputed element. Simply finding a buyer isn't enough. The broker's actions must have led to the sale. If another broker or the seller themselves finds the buyer, the broker with the non-exclusive listing may not be entitled to a commission. Procuring cause means the sale would not have occurred but for the broker's efforts.